Okay.
Can you hear him?
Maybe I'll take the mic and hold it by hand then.
Apparently he can't hear. He can't even hear me, much less you.
All right.
Okay. Pastor, do we have to call you Pastor?
You can call me whatever you like.
Oh, you don't want that? You may get the wrong. Pastor David Whitney, Senior, Robert, I can't read it.
Senior
instructor at the Institute on the Constitution. Well, that's very important. Also was, what's it?
Previously.
Previously what?
Spoken to this gathering.
Oh, yeah, we know that.
Yeah.
Supreme Court, what about the Supreme Court?
That's what we're going to speak on tonight.
Okay, he's going to speak on the Supreme Court tonight. I hope you do a good job because that's very important.
It is.
Do you like his new nominee?
I'll tell you, but I'm not going to tell you before I tell you.
Well, that's fair enough. It's all yours.
All right, well, let me see if I can get this.
I want you to impress our audience.
Okay.
What are you doing, my machine?
I'm going to take this microphone so I can be over here because the talk I'm entitling is Here Comes the Judge.
Pastor, make sure you don't take it home.
Oh, I won't take it home. No, I'll leave it right here. So we're going to talk about the Supreme Court and...
Turn that spotlight on me. What is that thing?
You got
the screen is right behind you. Yep. The reason why there's such a hubbub about Supreme Court nominees as we're going through right now, where everybody's very concerned about who's the next nominee. In fact, if you saw what the Democrats were doing, as soon as the idea of Kennedy resigning and retiring was voiced, they began to object immediately to anybody that President Trump would put into place. It's like, wait a minute, doesn't that sound like you've prejudged whatever nominee is going to be? And I thought all the Democrats were against prejudice, but they're all prejudging, and they've already condemned Kavanaugh and said, well, he's no good. Why? President Trump appointed him, and therefore he's no good. That's their rationale. But the issue I want to deal with, first of all, is why do we consider the Supreme Court so important today that there's this huge kerfuffle that takes place in our country when anyone is nominated, and there's a great debate that goes on, and everybody gets very uptight about it. Think of what our founders said, and by the way, sorry the picture is so dark here, but that's Alexander Hamilton, one of our founders, and this is what he said in Federalist Paper 78. By the way, the Federalist Papers were written as an argument for ratifying the Constitution. And Hamilton, Jay, and Madison wrote the Federalist Papers, and this is what he had to say about the judiciary, about the Supreme Court. And he was arguing essentially that the judicial branch of our three branches of the federal government is the least important and the weakest of all the branches of our federal government. He said this, that it had no influence over either the sword or the purse. It may be truly said to have neither force nor will, but merely judgment. And that's a direct quote from Federalist Paper 78. And basically he was paraphrasing Charles Baron Montesquieu, one who all of our founders read, his book, The Spirit of the Laws, where Montesquieu said of the three powers, the judiciary is next to nothing. So in our founders' view, they didn't have three equal branches of government. They had the strongest branch, which was the legislative Congress, the second, which was the executive, and the judiciary was the weakest. Well, if you haven't noticed in America today, that's been turned around. And today, the judiciary is the most powerful branch, and the executive the next, and the weakest is Congress. And that's not at all our founders' design. And we have had our system, our constitutional system, perverted by those who have done so since then. Now let's talk just a little bit about what our Constitution literally says the functions of the court, the Supreme Court, and the other federal courts are. In Section 1 of Article 3 of our Constitution, it establishes the courts and says all judicial power vests, that is, it permanently resides in the Supreme Court and then in lower courts that are established by Congress. So judicial power vests only in the judiciary, not in the legislative branch. In other words, the legislature cannot function as a courtroom except in cases of impeachment. It cannot function as a judge. That's literally only for the Supreme Court and the lower courts. Now Congress, we know with the lower courts, has established many levels of these courts, but there's only one court that's required by our Constitution, and that is the federal Supreme Court. If all the other federal courts were abolished tomorrow, that would be perfectly legitimate, and Congress has the power to abolish or to change any of those federal district courts or circuit courts. Congress can abolish them, or Congress can add additional levels. One of the great myths that our Constitution clearly dispels is that the myth that the judges are in office for life. And you'll hear this during the debates. People say, well, if Kavanaugh's nominated, it's going to be for life. He'll never be. And it's like, no. The Constitution never says that a judge is put into place for life. It's during terms of good behavior. And that's not that he just plays nice in the sandbox with the other judges. No. Good behavior is that he abides by the Constitution, or in the case of 3 judges, that they would abide by the Constitution. If they do not abide by the Constitution, that's not good behavior. And does anybody know what the remedy for that is? Impeachment, exactly. They should be impeached when they do not abide by good behavior, when they do not uphold the Constitution. And we'll talk about some judges that I think will be kind of good candidates for impeachment when we look at some of the things that they have said. So judges hold office during good behavior, not for life. And the framers designed a system that they wanted judges to be insulated from political pressure. And Gouverneur Morris, one of our most significant founders, wrote this. He was part of the Constitutional Convention. He said, "Those who are charged with the important duties of administering justice should, if possible, depend only on God." Look at that. They say that our founders created a secular government? No, not at all. Gouverneur Morris said that the judges, they should depend on God and God alone. And if they're godless, that is, if they don't believe in God, then they're obviously not going to depend on God. And our founders would never countenance an atheist on the Supreme Court, but we have such today. So if we were to say, what is it that our founders were thinking as they put together the Article 3, that is the judiciary, I believe they were thinking of Micah chapter 6 and verse 8, where it's speaking of God. "He has shown thee, O man, what is good, and what does the Lord require of thee? But to do justly," I'll come back to that in a second, "and to love mercy, and to walk humbly with thy God." What does it mean to do justly? And who determines the standard of justice? And that's one of the most important issues here. Because today, the standard of justice is the whim of 5 out of the 9, right? So 5 out of the 9 say that they can redefine God's holy institution of marriage. And by the way, I think they're on the way to hell, personally, as a pastor. And I'd like to tell them that personally if they would listen to me, but they won't. But that they're on the way to hell because they think they are God, and they're above the God who created and designed marriage, so much so that they could redefine. That's blasphemy. And our founders would have never tolerated. So our founders were basing the whole idea of justice on the justice of the Creator God, the God of the Bible, and in His Word, God's Word, that's where we find justice. So we have commandments like the commandment, "Thou shalt not murder." Oh, pretty clearly. Justice to be done to those who murder, clearly they are to forfeit their lives. First-degree murder should be put to death. They're not here in the state of Maryland because Maryland has rejected God's standard of justice, and Maryland is refusing to do justly. Well, how about the 8th commandment, "Thou shalt not steal"? We all have a God-given right to property. Why? Because the Creator is the one who created the whole world, and He has entrusted us with the right to property. And as stewards of the property He has entrusted us, He holds us accountable. But if somebody comes along and steals our property to do justice, there's a biblical standard of what that means. They completely repay what they stole from you plus 100%. In some cases, depending on the asset they stole, it may be several 100%. But there is a standard of justice, and our founders understood that standard of justice comes from God's Word, the Bible. That is the standard they were basing it on. So to do justly, you've got to know what justice is and where justice comes from and who establishes the standard of justice. And it's not a bunch of lawyers wearing black dresses. Oh, I guess I'm not supposed to say that. They say, nah, that's kind of derogatory. But that's essentially, what's the difference between a judge and a lawyer? You all know that we don't have great respect for lawyers in our day because they have been so a corrupting influence in our society. The only difference between a judge and a lawyer is a black robe. I guess I could call it a robe, right? And so you take somebody and you put them through law school and they learn all this stuff and they're a lawyer and we don't have a great deal of respect for them, and all of a sudden they put on this black robe and we have all this respect for them, and they think, well, they can redefine marriage or they can determine when life begins, and all these things are, what? Why have we done that? We've done it because we've rejected as a nation, we've rejected God's standard of justice, which we ought to be holding them accountable to that standard and say, look, When you redefine marriage, you have shown that you are incapable of understanding justice and you are insane, essentially. And we ought to remove you from the bench. We ought to impeach you when you do such things. But we'll talk a little bit more about that. So our founders, when they were establishing the judicial branch, understood justice is rooted in God's law. Now, Article 3, Section 1 talks about their compensation not be diminished during their tenure. In other words, nobody should be able to monkey with their pay and reduce it, because that would give it a political influence and an interference with their duties. And let's talk about the most important aspect, I think, that people have lost that our Constitution clearly speaks about. And that is the jurisdictional boundaries of the Supreme Court. Today, I would argue that most people in America believe the Supreme Court has no boundaries whatsoever. That if the Supreme Court were to come and determine that eating chocolate chip cookies in this American Legion is illegal, that they could do so. They have no boundaries. They can do whatever they please. There's no part of life they can't invade and make a ruling and a decision that affects every one of us. That's not our founders' understanding of the jurisdiction of the Supreme Court. Article 3, Section 2, it says, and I'm quoting, all cases in law, that's in statutory law passed by the legislature, all cases in law and equity, those general principles of fairness, that in all those cases, arising under the Constitution or under federal laws or treaties. So we're seeing there's a jurisdictional boundary. These are the kind of cases that the Supreme Court can deal with. And by the way, there was an early challenge to this limitation, this boundary for the Supreme Court in a case that's called Marbury v. Madison in 1803. Chief Justice John Marshall of the Supreme Court there interpreted this language to authorize judicial review. That is the power of the court to strike down statutes on the ground that they are inconsistent with the Constitution and therefore invalid. And so he was actually expanding the power of the Supreme Court in a way that our founders had not determined. The founders never said the Supreme Court trumps the legislative branch and trumps the executive branch. No. They never said that. They said the Supreme Court's the weakest of the least powerful and the least important of the three branches. But Marshall was basically saying, wait a minute, the Supreme Court gets the final word as to what law is and what the Constitution means. He didn't say that as blatantly as it's said today, but that's indeed what most people in America today believe, which is why the fight over who becomes the next Supreme Court justice is so important to everybody, because they know, well, hey, this guy might strike down Obamacare, or this guy might do something about Roe v. Wade. There could be some enormous changes in our life based on this one nomination. My argument is, if we understand the Constitution, it should not be this way. The Supreme Court should not have all the powers that it has. The jurisdiction of the court in Article 3, Section 2 continues. And it's Jefferson, by the way, who was president at the time Marbury v. Madison was penned. He said that opinion's wrong. I disagree with the opinion of the Supreme Court, and I will not abide by. In fact, the case at issue, Jefferson refused to abide by the decision of the Supreme Court. You ever hear of that happening today? No, nobody dares challenge everybody bows down as if the Supreme Court is God and we got to do whatever it says. But Jefferson said, no. I'm the executive. The executive enforces the law. The Supreme Court has their opinion, but it's only an opinion. That's all the Supreme Court renders, opinions, not law. Now, the other aspect of the jurisdiction of the Supreme Court was involving foreign officials. That is, say you had an ambassador who committed a crime in America. Well, it wouldn't be the state in which the crime was committed that he would stand trial. Because he's representative of a foreign government, he would stand trial with the federal government through the Supreme Court. So cases involving foreign officials, cases involving admiralty or maritime law. So obviously, if you were 40 miles off in the sea, off of Ocean City, and a crime was committed on board the ship that you were on, Maryland really couldn't claim jurisdiction out there and say, oh yeah, that happened on our territory, because it was not in the state of Maryland, it was out to sea. So admiralty and maritime law makes sense that the Supreme Court handles that. Or controversies between states. So if the state of Maryland and the state of Virginia were in a conflict and they went to court, obviously it wouldn't make sense to go to court in Maryland's courts or in Virginia's courts. We could expect them to be biased, but we would hope that the Supreme Court here, in cases between states, would be unbiased. And also, Diversity of citizenship. That is, if you had a case between a citizen in Maryland and a citizen in Virginia, again, neither of those states' courts would be appropriate. It should be a federal court in which that is, or citizens of different states or citizens of foreign nations. Also, suits between a state and a citizen of another state or nation. And this, of course, was changed by the 11th Amendment, which basically said if a state does not want to be sued by you, who are not a citizen of that state, you cannot sue that state for any violation, any breach of contract, which, I'm not really fond of that idea of giving states the power to form a contract, violate the contract, and get away with violating the contract. That doesn't sound like a good idea to me, but that is the 11th Amendment to our Constitution. So if we were to look at the rest of Article 3, Section 2, it talks about two types of jurisdiction. The first we call original jurisdiction. This is a narrow range of cases involving, as I said, foreign officials, states as parties, and so on. The second category is appellate jurisdiction, all other cases with any exceptions that Congress shall make to that appellate jurisdiction. In other words, this second category, appellate jurisdiction, Congress has power to restrict that jurisdiction. Congress can limit the court's appellate jurisdiction and limit its judicial power. Congress has not used this check that they have in their hands. They have not used it against the Supreme Court in over 100 years. You wonder why? That's, I think, because most Americans don't know that their congressmen have this power, and therefore they don't speak with their congressmen when they ought to be using this power, and the congressman knows he can get away with ignoring this. Types of cases, for example, where the court could limit the appellate jurisdiction. Think of the Constitutional Restoration Act. This is Chief Justice Roy Moore, as you know, not in the most recent conflict, but the conflict before that, where the Ten Commandments were put into the Supreme Court building of the state of Alabama. It was all voluntary money. It wasn't taxpayers' money that put that monument in. And the federal court said he had to remove that monument. And they asked, why? Well, separation of church and state, which if any of you have taken our U.S. Constitution course, you know that that is a myth. But because the federal court said you have to remove the Ten Commandments monument, and Chief Justice Roy Moore said, no. You're invading a territory in the state of Alabama you have no right to do. He refused to obey the federal judge, and then he was removed from office by the corrupt judges of Alabama, and the monument was removed by the corrupt federal government. And so he proposed a Constitutional Restoration Act which would limit the power of the federal government and the Supreme Court particularly. Notice the language of it here. Notwithstanding any other provision of this chapter, the Supreme Court shall not have jurisdiction to review by appeal, writ of certiorari, or otherwise any matter to the extent that relief is sought against any element of federal, state, or local government, or against any officer of federal, state, or local government, whether or not acting in official personal capacity, by reason of that element or officer's acknowledgement of God as the sovereign source of law, liberty, or government. So essentially it's what he's saying here. If this act were to pass, it has not passed Congress, it would restrict the federal judiciary, the Supreme Court and all the federal courts, that if a person acting in capacity officially or even unofficially were to acknowledge God as the source of law and the source of liberty and the source of governmental authority, if they were to do that, there would be nothing that the Supreme Court or any federal court could do against them. In other words, what happened to Chief Justice Roy Moore in Alabama, forcing him out of office and removing the Ten Commandments monument, could not happen. Congress would be essentially stripping away a power that the Supreme Court claims to have today. Now, this has not been used, but it could be used if the people understand this and force it upon the federal government. So the original jurisdiction cannot be changed. That's involving foreign officials, admiralty law, controversy between states, diversity of citizenship. But the other category of the Supreme Court powers and the federal court powers, appellate jurisdiction, can be restricted by Congress. These are cases that begin in the state and they are appealed up to the Supreme Court, which is why they're called appellate. These cases appealed up to the Supreme Court, Congress can limit what type of cases can come before the Supreme Court, and Congress can actually take whole sections of law and say, this is outlawed, the Supreme Court cannot touch this matter. It will remain with the state courts, it cannot be appealed to the federal courts. And Congress has the power to do this. But they don't, because I believe we have not put the pressure on them. So original jurisdiction cannot be restricted by Congress, but appellate jurisdiction can be restricted by Congress. For example, take the issue of abortion. Many people say, oh, the only way to end abortion is to overturn Roe v. Wade, which requires us to have a Supreme Court that wants to overturn Roe v. Wade. And we'll see what happens here. I have my doubts about it, but let's imagine we were depending on that. How many years have we been depending on the Supreme Court to overturn Roe v. Wade? 40 plus years now. In 40 plus years, there's 60 million, that's 60 million babies been murdered by abortion because the American people have believed, oh, we got to get the right Supreme Court justice and then we can overturn it. No, we don't. All we need to do is have Congress pass a bill with similar language of what I just showed you there that basically says, as regards abortion, the Supreme Court cannot rule at all in any appellate case. In other words, if a case starts in a state, by the way, Roe v. Wade started in the state of Texas. So Roe said her rights were being violated because she couldn't abort her baby. And so it was appealed from the state courts up to the federal courts and the federal courts up to the Supreme Court. But what if you stopped it at the state line and said it can never get to the federal court? It would be very simple, and the language very similar to what I showed you could be done for abortion to say, Supreme Court has no authority any longer to rule on the issue of abortion. No case can be appealed up from any state to the federal judiciary regarding abortion. And then each state would be free. Now, obviously, there's going to be some states that continue murdering babies, California, New York, and you can name a bunch of others. But there might be some states that say, hey, we don't want any murder of babies in our jurisdiction, and we're going to outlaw abortion. By the way, there's one state governor that has promised to do this, the state of Texas. Governor Abbott has promised to end abortion in the state. What if he passed a law in this state that ended abortion? We know exactly what would happen with the pro-aborts. They would appeal it up to the Supreme Court for the Supreme Court to hear the case. But what if it stopped at the border of the state of Texas, and Texas decided within our jurisdiction, no more murder of any babies? Can't say what's going to happen in Louisiana or any other state, but in the state of Texas we can do that. All they need is a restrictive law from Congress that says the Supreme Court has no appellate jurisdiction over the issue of abortion. So it would look like this. Let's talk about abortion. Say, well, it's just taking 14% of the power of the Supreme Court away from them in regard to that. Or what if we think of a bunch of other things? How about Obamacare? How did we get Obamacare? The Supreme Court forced it upon us. There were some states that said we don't want it. In fact, there were some states that amended their state constitution to prevent Obamacare from coming to them. And what happened? Chief Justice Roberts folded like a cheap suit. Yeah. And we have Obamacare because of him. Well, what if the Congress were to pass a law that says, there is no appellate jurisdiction of the Supreme Court of the United States regarding health care whatsoever. No case can be appealed up from the state. So, hey, maybe we cut back 50% of the appellate jurisdiction of the Supreme Court. Or why not go even further and take 70%? Or how about even more than that? Why don't we, reduce the appellate jurisdiction to just a very narrow range of cases that will allow the Supreme Court to hear when they're appealed up from the state? Congress has the power to do this. Some of the congressmen know this, others do not. And if you vote in the coming election in November for your congressman, you ought to ask him if he knows his Article 3, Section 2 powers to restrict the appellate jurisdiction of the Supreme Court. Does he know this? Because if he doesn't, we invite him to take our course at Institute on the Constitution, where he can learn what his powers are as a congressman and what he ought to do to restrict the appellate jurisdiction of the Supreme Court of the United States. Congress has that power, but if they don't hear from we the people to force their hand, they're not going to do anything. You can expect them to sit on their hand and then they say, well, it's not our problem. We can't end abortion. That's the problem, the Supreme Court. No. They're lying. But some of them don't know, some I think do know that they're lying about the power they have as congressmen. Well, let's talk about some of the current justices on the Supreme Court and ask yourself this question. Who's the watchdog that ought to be overseeing these justices, and when they are not acting in good behavior, which is true, they're not being true to our Constitution, they're violating our Constitution, who's the watchdog that ought to rein them in, and by what mechanism ought they rein in an out-of-control Supreme Court justice? Congress, and what ought they to do? Impeachment, and that's the job of the House. So actually, there's an interesting case of impeachment going on right now with Rod Rosenstein. There's, I think, a dozen, Jim Jordan and some of the others, who are calling for the impeachment of Rod Rosenstein because of his violations of things that they've asked him to do. That, by the way, if Congress demanded any of us do what Rod Rosenstein's been told to do, and we didn't do it, guess where we would be? we'd be behind federal bars, right? We'd be in prison right now. But he's getting away with it. And so some congressmen know their duty of impeachment is they're trying to impeach him. But there's a whole lot of congressmen that won't get on board with that. But look at Sotomayor. Notice what Time magazine said about her. You almost can't read it there. Latina justice. What? I'd never heard of this before, but what is Latina justice? Is that what happens in Mexico, when the drug cartel takes over a town? Latina justice, you find all these dead bodies. Is that? I don't know what Latina justice is, but it doesn't sound constitutional to me. I've heard of constitutional American justice, but what is Latina justice? Well, I got an idea here as I read her quote of what she thinks Latina justice is. In 2001, and by the way, she wasn't on the Supreme Court in 2001, but she was judge in a federal court and an appeals court, and she stated this in her speech: "I would hope that a wise Latina woman with the richness of her experiences would more often than not reach a better conclusion than a white male who hasn't lived that life." Well, excuse me, but does that sound even a little bit racist? Latina better than white, that sounds racist to me. I don't know about you, but okay, racist for one, but also sexist. She's saying a woman judge will do a better job than a male judge any day of the week. Okay, so she's a racist, she's a sexist, and obviously she's not interested in justice by some objective standard. Her justice is her as a Latina woman, whatever she conceives justice to be in her mind, that's the standard. Contrast that with our founders that I shared before. They believed God's word, God's law, the Bible is the standard of justice. So when God's word says thou shalt not kill, and the baby in the womb is a human being, and if you do damage to that human being in the womb, here's the penalties. They're spelled out in the Old Testament. It's very clear. So when this justice says murdering babies in the womb is just, we have to say, wait a minute, you made that standard up in your own mind. You're not following the creator of the universe, the God whom our founding documents refer to when they talk about the laws of nature and nature's God in our Declaration of Independence. It's directly referring to the God of the Bible, and we show that in detail in our U.S. Constitution course. But this justice doesn't hold an objective standard. It's all in her mind, and whatever she conceives of, well, her life as a Latina woman has given her all the wisdom to decide what's just and what's unjust. Sorry, I don't want that for my Supreme Court justice, and somebody like that ought to be removed, ought to be impeached from the bench of our Supreme Court. Or how about this gal? Is 80-some years old, I guess, now, and I think she's trying to compete with, who was it that retired at 90? Anyway, she's trying to make it to 90, I guess, so we'll see if our good God in heaven allows that. But anyway, Justice Ginsberg has said some very interesting things in her career. When asked about the Constitution, here's what she said: well, some things I'd like to change. One is the Electoral College. So she hates our Electoral College. It's like, well, I thought you swore an oath to the Constitution as it was written, which means you should have no opinion about changing the Constitution because you as a judge have no power to alter anything in the Constitution. And you shouldn't be speaking about altering anything because you've just basically violated your oath of office. Yes, congressmen can talk about that because they have the power to amend the Constitution through the amendment process of Article 5. Yes, they could do that. But Supreme Court justices should never speak like this. And then she was asked on TV, over Egyptian TV, by the way, not American TV. She was asked about her opinions regarding our Constitution. And she said she would not, I have to emphasize that word not, she would not recommend using the United States Constitution as a model for writing a modern day Constitution. She doesn't like our Constitution. She didn't think it was a good idea. She doesn't think they did a good job. Again, somebody in this position is likely to start legislating from the bench, amending the Constitution from the bench, saying things like Obamacare are legal when we know they're blatantly illegal, they're a blatant violation of our Constitution, and on it goes. And so we have an out-of-control Supreme Court because we've got justices on there who hold a completely corrupt view of our Constitution And I would add a complete corrupt view of what justice is and what the standard of justice is. So we, the people, ought to be speaking with those who represent us, because especially in Senate here, they're going to be issuing their process of evaluating Judge Kavanaugh and so on. But if they don't have the proper understanding of what a Supreme Court justice is about and what a Supreme Court justice is supposed to do, they might make a bad decision. They might cast the wrong vote as a senator, which means it comes back to the question of, do they, as a senator, hold to a constitutional standard of our founders? Sad to say, here in Maryland, our 2 senators do not. Both of them fail the test miserably. And they don't hold to anything that is safe for our God-given liberties. And that's what our founders would say. If our founders could be here tonight and say, looking at the lay of the land and looking at what's going on right now, your God-given rights are being attacked far worse than ours were under King George III. That's right. Because King George III would never imagine some of the things that our federal government is imposing upon us in violation of our God-given rights to life, to liberty, and to property. So here's another justice that I'd put up for impeachment if I had a position in Congress. In fact, I asked my congressman, I'll leave his name out because he's not my congressman now, because our redistricting, we were in the worst redistricting case in the history of the United States. If you've ever seen our district, it snakes all around the state of Maryland. There's one section, I think, that there's no houses, it's just a road. In other words, the district goes down the middle of the road and no houses on either side of the road are part of the district. What is with that? Well, that's what happens when Democrats run the state of Maryland. So anyway, so he's no longer my congressman. But I asked him while Obama was in office, I'll just say in office, I won't, or resident, but when he was in that position, and I asked him, would you consider impeaching Obama? And I mentioned a list of things, and I said I'd be willing to give him a long list, page after page, of violations of the Constitution that Obama had done at that point in time. And he said to me, he knows me, actually, he took the course at one point. He said, David, that wouldn't do any good. It wouldn't go anywhere. And I said, that's not what I asked you. I wasn't asking you for political expediency. I was asking you to do your duty as my representative, to file an article of impeachment, even if it doesn't go anywhere, which is why right now I'm applauding, I think it's 12 members of the House that have filed for impeachment of Rod Rosenstein. Even if they don't succeed, even if Rosenstein's not impeached, they did their duty. They recognized who it is should be impeached, and they acted upon it. In fact, I would encourage you, if you're able to have a conversation or even send a question to your current representative in the House of Representatives who's standing for election in November, ask him, what is his list of people in Washington that he recognizes he needs to impeach? Or if you have a candidate who's running for office but isn't in the House currently, but is hoping to be in the House, you should ask him that same question. If you were to win this election and you'll be in the House of Representatives, who do you plan to impeach? And most of them will look at you like deer in the headlight. I don't plan to impeach anybody, because they don't know their job. And that's one of the most important jobs they have. Find all the corrupt federal officials. And boy, that's not hard. You just got to throw a dart anywhere. Find all the corrupt federal officials and file articles of impeachment, because it can make a difference, even if you don't succeed in actually removing them from office. Let me cite an example here in the state of Maryland. You may not remember this. Back around 2000, I think it was 2 or 3, there was one lowest judge on the totem pole in Maryland, in the city of Baltimore, that declared Maryland's marriage laws to be unconstitutional. And so it's unconstitutional if only a man and a woman can marry. Oh no, we got to have it so that a man can marry a man and a woman can marry a woman. And this is, and this judge declared this and basically threw down the challenge of overthrowing Maryland's marriage laws that has stood in existence since the foundation of Maryland as a colony, overthrowing those entire laws by the edict of one black-robed lawyer. And there was only one delegate in the House of Delegates down in Annapolis willing to stand up to that kind of tyranny. And it was interesting to see how this Republican was treated. There was other Republicans begging him not to do this. Don't call for the impeachment. This is terrible. You can't. And it's like, no, if you understand the Maryland Constitution, that's the duty of the House of Delegates, that they impeach anyone who violates their oath of office in any of the branches. And so he stood up on the floor and he called for the impeachment of this one judge. and nobody stood with him. He stood alone, so obviously it failed. But did it fail? No. You know what happened? Is all the judiciary in Maryland backed away from the strategy they had of overturning marriage law in Maryland. They recognized one person stood against them, one person called for impeachment, and every judge is always worried about climbing the ladder, and any black mark on their record, including just somebody calling for their impeachment, is enough to prevent them from going up the next rung of the ladder. And so one lonely and one unsupported delegate stopped the redefinition of marriage in Maryland by the judicial route. Now, obviously, they did it then by the legislative route, and I'm not sure we had an honest election, but that's all beside the point. But in other words, when somebody in the House, whether the House of Delegates here in Maryland or in the U.S. House, they do their job of calling for impeachment, what it does is it fires a shot across the bow of corrupt officials, federal and state, and may cause them to back up and say, you know, Rod Rosenstein might say, ooh, I better hand over all those papers they're demanding of me that I've been holding and putting in the shredder and things like that. I better do what I'm supposed to be doing because, you know, this one call for impeachment might actually work. So if our representatives in the House, federal and state, do not do their duty, what happens is we have an out-of-control federal government and state government. We have out-of-control justices like this who get away with making statements like that, and they're never called on the carpet for that. So, of course, you're very interested in what I have to say about what's happening in the Supreme Court today and the whole nomination process. By the way, everything has been handled properly constitutionally. The president, he has the authority, by whatever means he chooses, to select a nominee to put forward. And there's been a great hue and cry on the part of the left. Oh, he's talking to the Heritage Foundation. He's talking to this group or that group. He could talk to anybody he pleases. He could come here tonight and ask you, who do you think is a good, nominee for the Supreme Court? He is not restricted in who he looks to in terms of his decisions. So that's constitutional. Now, of course, they're about to start the hearings, and that'll be going forward. So the Senate is required to vote, and we'll see how that goes, because there is a majority of Republicans, although there's some very, very bad Republicans from Maine and what's the other one? Oh, from Alaska. So the two most northern states have very bad senators that are likely to vote against him, so we'll see. But my greater concern is this. Our founders designed our judicial branch as a legal institution. A legal institution, obviously, is supposed to be blind to racism or sexism, not supposed to be making decisions based upon some Latina justice or something like that. No, they're supposed to be blind because they're objectively observing the issues and not the people that come before. They're not supposed to be prejudiced. But it seems to me what we have at the Supreme Court and the federal courts today has become just another political institution. In other words, they're getting feedback from here, and they're making decisions not based on any fixed standard of law and not based on our Constitution, but they're just acting like regular politicians, making decisions that have nothing to do with the standard of justice. And this is why our Supreme Court today is so corrupt. So what about Judge Kavanaugh, the current nominee? Many people want to know what Judge Kavanaugh would do with the issue of Roe v. Wade. Would he oppose Roe v. Wade, or would he uphold Roe v. Wade? I cannot know what he would do once he is in the Supreme Court. Only God knows what will happen there. But I do know what he said when he was being confirmed for the D.C. Circuit Court, which is the current position he holds. And he said this: I would follow Roe v. Wade faithfully and fully. That would be binding precedent of the court. It has been decided by the Supreme Court. I don't know that he'll stick with that. Maybe he will, maybe he won't. But I do know I disagree with his philosophy there. And his philosophy basically says, once the Supreme Court has made a decision, then we must follow that precedent again and again and again and not overturn that precedent. Well, if that were the case, perhaps you don't remember the case because I don't think any of us were alive, but the case of Dred Scott. Remember the Dred Scott case? Where blacks as slaves were declared basically non-human and had no rights, no civil rights at all. That was never overturned. In other words, the Supreme Court never came along after Dred Scott and later said, you know what, Dred Scott has been vacated. It's no longer functioning as a Supreme Court decision. No, what happened is everybody ignored Dred Scott. They ignored the opinion of the Supreme Court because the Supreme Court can never enforce its opinions. The other branches are involved in the enforcement, but the Supreme Court has no power to enforce any of its opinions. And so it was just ignored. Well, you could think of a bunch of others. I think it's Buck v. Bell is the case that allowed states to choose to sterilize women that they deemed unfit to reproduce. You know that was done up until the 60s? The state of Virginia right next door to us, they were doing it. They were sterilizing women based on their opinion of what was a valid or invalid person in terms of whether they could reproduce and have children or not. And that was the Supreme Court. And was that case ever overturned? No. People just said, that's wrong. And we're going to ignore that. And that's what I would say about Roe v. Wade, because Roe v. Wade essentially says that a woman has the right, and I'll put right in quotes because it's a wrong, it's not a right, to hire a contract killer to murder the baby in her womb. And the Supreme Court said in their case, Roe v. Wade, in part because they couldn't tell when life began. Well, yeah, they were ignorant. They didn't have as much science as we have today, but we know life begins at the moment that single cell, that egg, is fertilized and splits into two. That is a human being. And it's a human being, and it has its own DNA. It's not part of the woman's body. It's a separate human being made in the image of God. And the only thing it needs is time. Time, usually 9 months in the womb, to grow and develop in size so that it can be independent of the mother. But it is no different than you and I. It's a full human being and ought to be treated with that same respect. And so I don't believe Roe v. Wade was decided correctly. First of all, it's not in the jurisdiction of the Supreme or the federal courts at all. Should never have been allowed to come to the federal court whatsoever. And furthermore, was decided wrongly because it was basically saying you can murder a human being. And God's law says, thou shalt not murder. No exceptions. Thou shalt not murder. And just because it's decided by the Supreme Court does not make it right. So I'm praying for Judge Kavanaugh that he would change his opinion here regarding Roe v. Wade, and I trust that he will. The other issue that other people are asking about, let's see if this will come up here. There it is. That he was involved in working for Mr. Starr. You remember the big controversy that surrounded the criminal family, the criminal crime syndicate called the Clintons? You ever heard of that criminal crime syndicate? There's a lot of dead bodies, more than 100 dead bodies last I read that seem to be connected in some way, shape, or form with the Clinton crime family, one of which is Vince Foster. And Judge Kavanaugh, when he was working with Mr. Starr, concluded that Vince Foster had in fact killed himself. I don't know if you've looked at any of the evidence there, but how do you shoot yourself in the back of the head, drag yourself through the mud to there's a whole lot there that, I don't know, just doesn't look to add up to me, but he opposed the public release of the narrative portions of Mr. Starr's report detailing Mr. Clinton's encounters with a White House intern. And by the way, that quotation is from the New York Times, not a favorable source in general, but just what they have said. So I have if I could pick a Supreme Court nominee, I think there's stronger and better ones than Judge Kavanaugh, but I'd be happy to see him nominated to the Supreme Court, and he's been nominated and approved by the Senate. And I think he will be. I mean, there's going to be a real fight going on here, but the interesting fight, I think, is going to be of some of the Democrats who are in states or in districts that went for Trump. And they've got a real tough decision on their hand because they realize the people who voted for them last time as a senator, this time they might switch and they might not vote for him. And so if they don't vote for Kavanaugh, they might actually lose their election this November. And so it's interesting kind of to watch those Democratic senators who are standing for election in November, because they, depending on what the constituency, the changes in their constituency have happened, they may change their mind. They may actually vote for him, in which case the senator from Maine and the senator from Alaska may not make the difference regarding Judge Kavanaugh. So I know that what I'm sharing may not be the popular view among many conservatives who are very excited about Judge Kavanaugh. I'd love to see him confirmed, but I don't have a great deal of hope that we'll see Roe v. Wade overturned. The reason I say that is we were promised when Judge Roberts came in, we're going to see Roe v. Wade overturned. What happened? We got Obamacare instead. Judge Roberts was the deciding vote for Obamacare. So we were told this great conservative is going to help protect. Instead, he gives us Obamacare. And we've seen that with far too many Republican nominees. Anthony Kennedy, He was a Republican president. Reagan put him into place. Was it Reagan? Yeah, I believe it was Reagan put him into place. And he's been one of the worst, of the nominees. So just because they're nominated doesn't guarantee. What we really need to see changed is that Americans call the Supreme Court what it is. It should only have a very limited original jurisdiction and almost no appellate jurisdiction. All the cases that are appealed, and by the way, most of the cases we hear today, they're all appealed up from the states. They deal with almost nothing in their docket of original jurisdiction. Almost all of it is appealed. What if it stopped at every state border and the state courts were the ones that were the final word on those decisions rather than our Supreme Court? Well, I think I might have a minute or two for some questions. Okay, yeah, so you might have a question or two. Yes, Kevin.
It sounds like you're saying two different things. You're saying that the House can determine what goes up to the Supreme Court. They can say no. But then I also hear you using language a lot of conservatives use, even liberals, getting your hopes up about the Supreme Court like it's this great thing. They're going to decide all these things. But to me, that sounds opposing. If they're not supposed to decide all this stuff, then why is there all this excitement?
Well, I agree. And I'm saying I'm not excited. It's happening, even though I recognize if you replace Kennedy with somebody even a little bit more conservative, that's movement in the right direction. But the real solution is not at the Supreme Court. The real solution is for Congress, the House, and the Senate to restrict the appellate jurisdiction of the Supreme Court so that they cannot be making all these disastrous, and then to do things like that Constitutional Restoration Act, which would say that, okay, you decided Roe v. Wade, that's no longer considered a standing any longer. The states each get to decide what they're going to do with abortion, and the federal government is out of the decision-making issue on that. And the federal government's out of the decision-making on Obamacare, and on the list can go, that Congress can say, that's off the plate. Supreme Court cannot hear any cases, or no federal court can hear any cases regarding that.
What part of the Constitution does it say that Congress?
Article 3, Section 2 of our Constitution says that Congress has the power to restrict the appellate jurisdiction of the Supreme Court and of all the federal courts. So we ought to be asking our representatives, do you understand Article 3, Section 2 power? And are you willing to put legislation forward based on Article 3, Section 2, restricting the appellate jurisdiction of the Supreme Court? And if they need language, well, we can give them Chief Justice Roy Moore's language of the Constitutional Restoration Act as an example of what they could do. Yeah.
Pastor, he's got a question.
Yes,
I
Bob.
hear the term judicial precedent,
Mhm.
and being a lawyer, I assume that it has validity in the judicial decision process. But I also think it has a pitfall, and that is, for example, to use the analogy of a bridge collapse compared to judicial precedent. If, by comparison, you had a bridge collapse and an engineering firm come in to replace the bridge, similar to judicial precedent, they might say, well, we have to design the new bridge like the old bridge because the previous engineering firm designed it that way. So based on engineering precedent, we have to simply repeat the same structure, and that seems to be disastrous.
It does. Basically, we need to say wrong for the Supreme Court to be in the bridge building business at all. Let's return that to the states. And yes, the state Supreme Courts can make decisions that are going to determine that, but it's not the job of the federal judiciary to do that. Yeah. Great question. Yes?
I thought that in the past legislation that they lowered the marriage age to 16 or 17 if in fact the woman was pregnant and may have had parental consent. Is that true?
Yes, parental consent is required. 18, beyond age 18, right. It's not
So
parental
it's not
consent's
only
not
the fact that
required.
she's pregnant, they need both the
Right.
pregnancy and
Well, actually, pregnancy is not required as long as there's parental consent. A 16-year-old can marry, even if they're not pregnant. Yeah. So they've lowered that age, but it's with parental consent that can be done. Yeah.
I was concerned about Sharia law and allowing that to take place, if that's the case.
Yes, I mean, it may be related to, trying to implement parts of Sharia law. And that should be a concern of ours, because Sharia law is directly contrary to biblical law in so many ways. We take a whole session just to talk about the contrast, but if Sharia law is imposed, you lose your God-given rights to life, to liberty, and to property, unless you become a Muslim. Then you have special rights as a Muslim that the non-Muslim doesn't have. So it's a completely opposite of our founder's system, where the fact that you're created in the image of God, therefore you have God-given rights. Doesn't matter what your religious belief is, your God-given rights are secured. Yeah. Good question. Yes, sir.
Newt Gingrich mentioned that at one point the president disbanded a couple of courts, and he got away with it.
That should not have happened. I mean, Congress can do that, disband, but not the president. Yeah. Yeah. Very dangerous.
And he's a historian, so where he got his source from.
Yeah. Yeah. That's.
Talk about FDR and try to
Oh,
backboard.
yes. They try to, yes.
Can I call on the next?
Yes, you can. Thank you so much for your attention.